5 seconds to go. Start. Apart from the submissions aforesaid, it is noteworthy that though on behalf of the respondent number 2 corporation, the reply submissions are essentially to the effect that in the departmental proceedings, charges were not proved against the present appellant, but then in the counter affidavit on behalf of the respondent number 1 state, detailed submissions have been made, essentially refuting the case of the appellant. It has inter alia been submitted on behalf of the respondent state that apart from the present matter being barred PS case number 115 of 2012, there had also been another matter being Bikram PS case number 129 of 2012 against the respondent number 3 as also the present appellant, and after the order passed by the High Court, the investigation in the present case was also carried out by the Economic Offences Unit Bihar along with the aforesaid Bikram PS case number 129 of 2012. While indicating prima facie complicity of the appellant, it has also been pointed out that it remains a statutory mandate. In Popular Muthaiya Supra, of course, this court held that the said appellant against whom the High Court was issuing directions for investigation should have been given an opportunity of hearing, but that had been the observation in the unique and peculiar circumstances of the case, where the crime in question had already gone through one round of trial with one person having been tried and convicted. Moreover, while disapproving unwarranted directions of the High Court as regards prosecution of the appellant, this court also indicated that the High Court ought to have considered if any purpose would be served by its directions. It cannot be said that in Popular Muthaiya this court has laid down a rule of universal application that in every such case of exercise of powers under section 482 CRPC for ordering further investigation which are even otherwise to be invoked sparingly and in exceptional cases, the court is obliged to extend an opportunity of hearing to the person whose actions omissions are to be investigated. In our view, the question of opportunity of hearing in such matters would always depend upon the given set of facts and circumstances of the case. On the facts and in the circumstances of the present case, we are clearly of the view that no purpose would be served by adopting the course of Popular Muthaiya Supra, where this court restored the matter for reconsideration of the High Court with an opportunity of hearing to the appellant therein. Some of the prominent and peculiar circumstances of the present case are that the allegations and imputations have their genesis in the documentary evidence in the form of departmental instructions and the audit report. The fact that the appellant was holding the office of the district manager at the relevant point of time is not in dispute, and herein before we have upheld the exercise of inherent powers by the High Court in directing further investigation qua the role of the appellant. Stop.